Hello, hi, and welcome to the third session of Negotiable Instruments Act 1881. So, the first topic in this session is legal provisions relating to capacity of parties to the negotiable instruments. So, the parties to the instruments will be every person who is capable of contracting and every person through duly authorized agent. Every person through a duly authorized agent can be a parties to a negotiable instrument. And let us discuss about the capacity of parties with respect to a negotiable instrument. So, the capacity to make or the capacity to draw or the capacity to accept negotiable instruments with respect to any parties in that and as per the NI Act will be given under section 26. So, capacity to make or draw or accept a negotiable instrument. So, the Act says every person capable of contracting, every person, whoever is capable of entering into a contract with any other party, may bind himself and be bound by the making of a bill or by drawing a bill or accepting a bill or endorsing and delivering a bill and negotiation of a promissory note, bill of exchange or check. So here the law clearly says that every person who is capable of contract according to law to which he is a subject may bind himself and be bound by all the making or drawing or accepting or endorsement or delivery and negotiation of any of these three instruments, that is, one a promissory note, second a bill of exchange, and third a check. So when it comes to a minor, the law has provided a kind of protection to the minor. So a minor is allowed to be a party to the negotiable instrument, but if something goes wrong, if that instrument dishonors or if that instrument is dishonored due to non-acceptance or non-payment or some other reason, in all such cases, the minor will not be liable. The minor will not be liable, right? So here a minor may draw or endorse, deliver, and negotiate such instruments so as to bind all parties except himself. So this is the crux in case of a minor. He can bind all the parties to the bill that he draw, endorse or deliver and negotiate, but he cannot bind himself to any party. A minor's agreement is void and cannot be ratified when he attains the age of maturity. So, a minor cannot bind himself under a negotiable instrument as his contract is absolutely void. So, nothing herein contained shall be deemed to empower a corporation to make, endorse, or accept such instruments except in cases in which, under the law for time being in force, they are so empowered. So let us see an example where you will understand the minor's capacity and how a minor is being exempted from the liability while leaving all other parties to the contract will be binding. This example says that A draws a check in favor of M. A draws a check in favor of M, a minor. So A is the drawer of the check and M is a minor on whose name the check is being drawn. And M, instead of getting cash, he endorses the same in favor of Mr. X. Right, he endorses the same in favor of X. The check is dishonored by the bank on grounds of inadequate funds. Here, in this case, M, being a minor, may draw, endorse, deliver, and negotiate the instruments so as to bind all parties except himself. So, therefore, what the inference you can draw? Therefore, M is not liable. X can thus proceed against A. Here, X is an endorsee and M is an endorser. So, X, who is an endorsee, and the payee, whose check is being dishonored due to inadequate funds in A's bank account, can make Mr. A liable and proceed against A instead of M. The reason is that M cannot be binded, being a minor, to any liability as a party to a negotiable instrument. And the next concept with respect to authority to sign: every person capable of incurring liability may bind himself or be bound by duly authorized agent acting in his name has a authority to sign as per section 27. So now let us discuss about legal representative. A legal representative of a deceased person. Here, a deceased person means the person who is no more, the person expired, who signs his name on promissory note or bill of exchange or check is liable personally thereon unless he expressly limits his liability to the extent of assets received by him. So, a legal representative who signs his name on a promissory note or bill of exchange or check is liable personally thereon unless he expressly limits his liability by stating that to the extent of assets received by him from the deceased person. Right. So, thus, in the absence of express contract to the contrary, the liability of a legal representative is unlimited. However, a legal representative may, by an express agreement, limit his liability. Further, he may exclude his liability by adding the words like sans recourse, which means to say without recourse. He will be keeping himself exempted from any future liability due to dishonor of a negotiable instrument. So, this is all about the legal representative of a deceased person. So, in case of an endorsement by legal representative, a legal representative of a deceased person cannot negotiate by delivery only. A promissory note or bill of exchange or a check payable to order and endorsed by the deceased but not delivered. See, a legal representative of a deceased person cannot negotiate by delivery only. Which means to say, if the deceased person he signs a negotiable instruments and keeps with him but not delivered. So, in such a case, the legal representative cannot make the delivery of that particular negotiable instrument that do not constitute a negotiation, which mean to say a transfer of property in the instrument from one person to the another person. A legal representative is not an agent of the deceased. Therefore, a legal representative cannot complete the instrument if the instrument was executed by the deceased but could not be delivered because of his death. See, if you see this example, you will understand it. A, the holder of a bill to B, A, the holder of a bill to B, before delivering the bill died. So, the legal representative of A subsequently delivered the bill to B. The endorsement is invalid. The endorsement is invalid and B cannot sue the bill because whoever is executed the bill, A, who was a holder of the bill, he executed the bill, he only has to deliver the bill to Mr. B. Then only the negotiation is complete. And if a part of the negotiation is done by the holder of the bill and the next part, if it is done by a legal representative of the deceased person, then in all such cases, this negotiation is not complete. The endorsement will become invalid and B cannot sue on that particular bill. A general authority given to an agent to transact business and to receive and discharge debts does not empower him to accept or endorse bills of exchange so as to bind his principal. So the conclusion says that an agent may have the authority to draw bills of exchange but not endorse them. An authority to draw does not imply an authority to endorse. So this is certain concepts which were given under parties to notes, bills and checks. Could it be a minor or could it be a legal representative or could it be an agent? So the next topic is what are the liabilities of the parties? So, like agent or legal representative, drawer, drawee, maker of note or acceptor of bill, or endorser, prior parties to the holder in due course, and prior parties as a principal in respect to subsequent party. For all these different kinds of parties that we come across in the negotiable instruments will have a kind of liability which is unique and specific with respect to their role. So that we will study now. Liability of agent. An agent who signs his name to the promissory note or bill of exchange or a check without indicating thereon that he signs as agent or that he does not intend thereby to incur personal responsibility is personally on the instrument except to those who induced him to sign upon the belief that the principal only would be held liable, he does have a personal liability. See here again I am explaining you this concept. An agent, if he signs on either the promissory note or bill of exchange or a check without indicating that while signing that he is the agent. So if he does not sign as an agent, then what happens is that he cannot bind the principal liable for any dishonor of the negotiable instrument. So as he does not sign as an agent, then what will happen? he will have the personal liability on the instrument. So there is an exception. So, except to those who induced him to sign upon the belief that the principal only would be held liable. If the other party induces him to sign, stating that if it fails, you are not the responsible, but your principal will be the liable. If they induce the agent in such a way, only such is the an exception where the agent's personal liability will be exempted. In all other cases, if it is signed without mentioning that he is an agent, in all such cases, he will be personally liable on the instrument. So, that is about the liability of an agent. And when it comes to a liability of a legal representative, a legal representative of a deceased person who signs his name to a promissory note, bill of exchange, or check is liable personally thereon unless he expressly limits his liability to the extent of the assets received by him as such. This we discussed in the earlier topic also. And the liability of a drawer of a bill of exchange. The drawer of a bill of exchange or check is bound in case of dishonor by the drawee or acceptor thereof to compensate the holder, provided due notice of dishonor has been given to the drawer as hereinafter provided. The liability of a maker of promissory note is primary, while the liability of the drawer of a bill arises on dishonor by acceptance or non acceptance by the drawee or acceptor, respectively. Right, this is all about the liability of a drawer of a bill of exchange. So, in case of a promissory note, the maker's liability is primary, whereas in case of a bill of exchange, the drawer's liability will arise only when that bill is dishonored due to dishonor by acceptance or non acceptance by the drawee or acceptor, respectively. And the next one is the liability of drawee of check. You know that in case of a check, drawee is always a bank. So, what is the liability towards a bank in general? If a customer is having sufficient balance and issues a check to a third party, and if the amount is not paid and if the check is dishonored, in all such cases, whatever the loss or damage caused to the customer of the bank and who is a drawer of the check, that has to be borne by the bank only. Here means bank is a drawee. Let us see that under section 31, the drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required so to do, and in default of such payment, in case of default of such payment, must compensate the drawer for any loss or damage caused by such default. So this is what it is given. So the drawee of a check must always be a banker. The drawee bank is bound to honor the customer's check if he has a sufficient funds of the drawer applicable to the payment of such check. If the drawee bank wrongfully dishonors the check, it can be made liable for such default. Naturally, the bank will be made liable for default because the money is available and it has to make a payment of the check, but it doesn't do. As a result, if some loss happens to the drawer of check, in all such cases, the drawee bank will be held liable. The liability for such default is not towards the payee or the holder, but towards the drawer. Towards the drawer. A bank is liable for a dishonor of check to the drawer who is a bank's customer only and not to the payee or the holder of the check, as there is no privity of contract between the bank and the payee or the holder of the instrument. So this is all about the liability of a drawee of check. And the next liability of maker of note. Note means here promissory note, and acceptor of a bill. Acceptor of a bill, who accepts the bill, who is also called as a drawee. So what is the liability? In the absence of contract to the contrary, the maker of a promissory note and the acceptor before maturity of bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of the note or acceptance. According to the apparent tenor of the promissory note or acceptance of a bill, and the acceptor of bill of exchange at or after maturity is bound to pay the amount thereof to the holder on demand. Right. So in default of such payment as aforesaid, such a maker of promissory note or acceptor of a bill of exchange is bound to compensate any party to the note or bill of exchange for any loss or damage sustained by him and caused by such default. So it is the liability of the maker of the promissory note and the acceptor of the bill of exchange for any loss happens to the payee. And the next one is liability of endorser. You know that endorser happens when a bill of exchange is being endorsed by the payee to some other person, and the payee will become the endorser and the endorsee will be the payee, and the same payee before maturity of that particular bill to can endorse to someone else depending upon his requirement. So such an endorser's liability, what it is given in section 35. In the absence of a contract to the contrary, whoever endorses and delivers a negotiable instrument before maturity without in such endorsement or expressly excluding or making conditional his own liability is bound thereby to every subsequent holder. So, an endorser is liable in the absence of a contract to the contrary to all the parties who are subsequent to him as an endorsee. In case of dishonor by the drawee or acceptor or maker, to compensate such holder for the loss or damage caused to him by such dishonor, provided due notice of dishonor has been given to and received by, and such other endorser has thereafter provided. In all such cases the endorser is personally liable to all the subsequent holders. Every endorser after dishonor is liable as upon an instrument payable on demand. So the next one is the liability of a prior parties to holder in due course. Every prior party to a negotiable instrument is liable thereon to a holder in due course until the instrument is duly satisfied. Duly satisfied means honored by the person who is liable to make a payment to the payee. So prior party, a principal in respect of each subsequent party. Right. This is a as between the parties so liable as sureties. Each prior party is in the absence of a contract to the contrary also liable thereon as a principal debtor in the respect of each subsequent party. Say for example A B C D E is there. A is the drawer and B is the drawee. And if the drawer of the bill Mr. A endorses that to C and C endorses that to D and D endorses if it is to E and every endorser is liable to the endorsee, his own endorsee. Let us see this example for your understanding. A draws a bill payable to his own order to B. A draws a bill payable to his own order on B, who accepts it. B is the acceptor and A is the drawer. After accepting that particular bill, he will return that to A. And A afterwards endorses it to C. And A is here endorser and C is the endorsee. And C endorsed that to D. And D endorsed that to E. As between E and B is the principal debtor and A, C, D are the sureties. As between E and A is the principal debtor, C and D are his sureties. As between E and C is the principal debtor and D is his surety. It is like that. Whoever is a subsequent to him, all of them will become the sureties and he will be the endorser will be liable to the holder of the bill. So it is the prior party a principle in respect of each subsequent party concept as it was given under section 38. Right. And the next topic is right the legal provisions relating to presentment of negotiable instruments. Right, the legal provisions relating to presentment of negotiable instrument. So what is meant by presentation? Presentation means showing the instrument, the drawee, acceptor or maker for acceptance or sight or payment. There are three kinds of presentments. See, for example, in case presentment of bill of exchange for acceptance. See, once the drawer or the maker of a bill, once he writes the bill, he will present it to the drawee for acceptance, right? Presentment of bill of exchange for acceptance is the one kind of presentment of negotiable instrument. Unless the drawee accepts the bill written by the drawer, it will not be a valid one. Second one is a presentment of promissory notes for sight. Presentment of promissory notes for sight. So promissory note will be presented for sight. In fact, the promissory note will be made and signed by the maker and will be given to the creditor. And presentment of negotiable instrument for payment, whether it is a promissory note or a bill of exchange, on the date of maturity, it will be presented for payment to the party who is liable to make a payment, right? Presentment for acceptance, let us see how it is being explained. The bill should be presented for acceptance by a person entitled to receive the payment. So, in most of the cases, the drawer of the bill will be the payee. So, he has to make a bill for acceptance in order to receive the money from the acceptor on the date of maturity. Thus, a bill must be presented by the holder or his duly authorized agent for acceptance. It is only a bill of exchange of certain types that need acceptance. It is only bills of exchange of certain types that need acceptance. A bill payable on demand or at sight or on a certain fixed date need not be presented for acceptance unless in such a case it is specially mentioned that such bill is to be presented for acceptance. So unless it is clear, it is mentioned such bill is to be presented for acceptance, it need not be presented for acceptance. In case of bills payable at sight or on demand, as there is only one presentment, if the bill is not paid, it is really dishonored for non-acceptance. So this is what a presentment for acceptance says. And next one is presentment of a promissory note for sight. Present promissory note payable at a certain period after sight and presented to the maker for sight by a person entitled for payment in a reasonable time in business hours on business days. So a promissory note payable at a certain period after sight must be presented to the maker thereof for sight by a person entitled to demand payment within a reasonable time after it is made and in business hours on business day. In default of such presentment, no party thereto is liable thereon to the person making such default. So presentment for payment under section 64, the presentment for payment, promissory note or bill of exchange on checks must be presented to the maker or acceptor or a drawee for payment and by on behalf of the holder. It can be presented by the holder or by an agent on behalf of the holder. In default of presentment, what will happen? Other parties thereto are not liable to such a holder. So it is the duty of the holder to make a presentment of the negotiable instrument on the date of maturity for payment. Promissory notes, bills of exchange, and checks must be presented for payment to the maker, acceptor, or a drawee thereof, respectively, by or on behalf of the holder, as hereinafter provided. In default of such a presentment, the other parties thereto are not liable thereunto, such a holder of negotiable instrument. And here, where authorized by agreement or usage, a presentment through the post office by means of registered letter is sufficient in some cases. There is an exception here where a promissory note is payable on demand and is not payable at a specified place. No presentment is necessary in order to charge the maker thereof. So, no presentment is required in order to charge the maker thereof. So, because not payable at a specified place. Time of presentment as per section 65. Presentment for payment must be made during usual hours of business. Usual hours of business of the maker of acceptor, of the maker or acceptor. In case of banker, presentment must be made within banking hours. Thus, a presentment made during unusual hours of business, though valid for the purpose of acceptance and sight, is valid for purpose of acceptance and sight, is valid for purpose of payment. So section 66 lays down that the promissory note or bill of exchange payable at a specified period after date or sight thereof must be presented for payment at the maturity. must be presented for the payment at maturity. Presentment before maturity is not a valid presentment. It is not a valid presentment. A promissory note payable by installments must be presented for payment on the third day after the date fixed for the payment of each installment, because there are three grace days are given. Non-payment of single installment has the same effect as a non-payment of a note at maturity. Thus, if a single installment is not paid, the whole of the note can be treated as a dishonored for non-payment. So this is what it says with respect to a promissory note. So it is regarding the time of presentment, and the next concept is regarding place of presentment. Regarding place of presentment. A promissory note or bill of exchange or a check made made drawn or accepted payable at a specified place and not elsewhere must, in order to charge any party thereto, be presented for payment at that place only. Otherwise, they cannot charge the party. Thus, acceptor will also be discharged in case an instrument is not presented at specified place. Acceptor will be get discharged in case the instrument is not presented at the specified place. So specified place implies the precise address of the place. The mere mention of a big city like Madras is not sufficient. So section 69 provides for the presentment of a bill or note made payable at a specified place in order to charge the drawer or the maker. And section 70 provides that where no place is specified, the note or bill must be presented for payment at the place of business. At the place of business or at usual place of residence of the maker, drawee, or acceptor thereof, as the case may be. It has been held that if the place of business is closed or abandoned, there is some other place where his business is conducted which can be ascertained from reasonable inquiries. Presentment at the former place is not sufficient. If the business is closed or abandoned, and it is the duty of the presenter to find the new place of business, and he has to submit the bill at the new place with a reasonable inquiries. Otherwise, presentment at the former place is not sufficient. And section 78(1) provides for cases when maker etc. has no known place of business or residence. If the maker, drawee, or acceptor of the negotiable instrument has no known place of business or fixed residence, and no place is specified in the instrument, presentment for acceptance for payment may be made to him in person wherever he can be found. So if you can see him in a hotel or on the road or in the railway station or bus stand, at any place wherever the drawer see the drawee, there it can be presented for payment, because there is no place is given in that instrument. So under section 71, this has been provided for to the holder of the negotiable instrument. So presentment of check to charge drawer. Subject to provisions of section 84, a check must, in order to charge the drawer, be presented at the bank on which it is drawn before the relation between the drawer and his banker has been altered to the prejudice of the drawer. So it has to be presented before the drawer and banker is cut off with relation with regard to their privity of contract. Presentment of instrument payable at demand. Presentment of instrument payable at demand. So, a negotiable instrument payable on demand must be presented for payment within a reasonable time after it is received by the holder. Excuse for a delay in presentment for acceptance or for payment. Delay in presentment for acceptance or for payment is excused if the delay is caused by circumstances beyond the control of a holder and not imputable to his default or misconduct or negligence. When the cause of delay ceases to operate, presentment must be made within a reasonable time. When presentment unnecessary, no presentment for payment is necessary, and the instrument is dishonored at the due date for presentment in any of the following cases. So if the maker, drawee or acceptor intentionally prevents the presentment of the instrument, no presentment for payment is necessary and the instrument is dishonored at the due date of presentment in any of the following cases. Let us discuss. So if the maker, drawee or acceptor intentionally prevents the presentment of the instrument, or if the instrument being payable at his place of business, he closes such a place of business day during usual business hours, or if the instrument being payable at some other specified place, neither he nor any person authorized to pay it attends at such place during usual business hours, or if the instrument not being payable at any specified place, he cannot after due search is not found. In all these four circumstances, dear students, the presentment of bill for payment is not necessary because he is not available in office during the usual office hours, and he is not available at his residence, and he is also not available at the specified place as it is given, and he is also not found anywhere even after a due search. In all such cases, the presentment of bill is not required. As against the next point, as against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. So in such a case, the presentment is not necessary. And as against any party, if after maturity, with the knowledge that the instrument has not been presented, he makes a part payment on account of the amount due on the instrument. So part payment is not considered as a payment and it will be as good as a dishonor. Promises to pay the amount due therein whole or in part. So a promise is not sufficient, it should be paid. Otherwise, waives his right to take advantage of any default in the presentment for payment. In all such cases, the presentment is not necessary. As against the drawer, if the drawer could not suffer damage from the want of such presentment, liability of banker for negligently dealing with bill presented for payment. When a bill of exchange accepted payable at a specified bank has been duly presented there for payment and dishonored, if the banker so negligently or improperly keeps or deals with or delivers back such bill as to cause loss to the holder, he must compensate the holder for such a loss. So this is with respect to a banker as it is given under section 77. So, and the next topic is that the legal provisions relating to payment and interest, to whom payment should be made, and with respect to the interest rate, how it is to be paid when no rate is being specified on a negotiable instrument, to whom the payment should be made is the subject to the provisions under section 82 clause c. Payment of the amount due on a promissory note, bill of exchange, check must, in order to discharge the maker or acceptor, be made to the holder of the instrument. The payment should be made to the payment of the amount due should be made to the holder of the instrument. Then only they will be discharged. Who are they? One is a maker or a acceptor in case of a bill of exchange. Right. So that the maker, acceptor or endorser respectively of a negotiable instrument is discharged from liability thereon by payment to all parties thereto if the instrument is payable to bearer or has been endorsed in blank, and such maker, acceptor or endorser makes payment in due course of the amount due thereon. So this is about to whom the amount is to be paid as it is given in the under section 82 clause C. Right now we see the interest when rate is specified and interest when no rate is specified. Right. So, where the interest rate is expressly made payable on promissory note or bill of exchange, interest shall be calculated at the rate specified on the amount of the principal money due thereon from the date of the instrument until tender or the realization of such amount, or until such date after institution of suit to recover such amount as the court directs. When no rate of interest is specified in the instrument, interest on the amount due thereon shall be calculated at the rate of 18% per annum from the date at which the same ought to have been paid by the party charged, until tender or realization of amount due thereon, or until such date after the institution of a suit to recover such amount as the court directs. So if it is mentioned, the exact rate will be collected. If the rate of interest is not mentioned, it is 18% per annum. Right. So with this, I would conclude the presentation of the third session, and the fourth session we will commence in the as a fresh one. Right. I thank you all, and best wishes to everyone as always.